Thank you very much, Japhet, for joining us, and a very warm welcome to you.
Uh, Thank you so much.
So, Japhet, 20 years on, and your report titled Protect the Court, Protect the People. Why does the court need protecting?
Thank you so much for this opportunity. The court indeed needs protection, primarily because of two important things. One is that over the years, in the last, as we celebrate this 20th anniversary, over the last 10 or so years since 2017, we have seen a number of member states that were parties to the court and that had allowed individuals and NGOs to access the court withdraw that declaration. We have seen their waning support for the court in terms of withdrawing their support. This includes countries like Tanzania, Rwanda, Cote d'Ivoire, Benin, and most recently, Tunisia. And therefore, we remain with very few state parties, just 7, that have allowed access to the court for individuals and NGOs. Secondly, of course, is the issue of the funding for the court. The court is not adequately funded and therefore struggles to execute its mandate of dispensing the promotion and protection of human rights on the continent.
This story sounds very much like the ICC. African nations have been saying that it was targeting unfairly African countries. So now we've got our own institution, and it seems that we have a problem with that as well.
Yes, it seems familiar, but there is one different aspect is that this African Court on Human and People's Rights was created by African states themselves in 1998 when they adopted the protocol on the establishment of the African Court. As we speak today, 34 African countries have ratified the court protocol. And one of the calls that we are making is that the rest of the African Union member states should also ratify the protocol so that it has universal ratification within the continent, so that all African and individuals across the continent can be able to access the court. And therefore, having created it, having ratified it, African states cannot not now turn back and say that they cannot support the court.
So if 34 have signed up, that's about 20 that haven't. What reasons have they put forward for their non-ratification?
Uh, Not many states have actually publicly or officially indicated the reasons for their non-ratification, but it primarily boils down to their reluctance to be held accountable for human rights violations and abuses. Unfortunately, we know that there is rampant human rights violations across the continent, and the question of impunity and accountability is an entrenched problem across the continent. And it is this lack of accountability and the entrenchment of impunity that makes many countries reluctant to ratify the court protocol that would allow the African Court on Human and People's Rights to hold them accountable for human rights violations and abuses when they occur and when they are not able to redress them at the domestic level. I must mention here that South Africa is one of the countries that has ratified the African Court Protocol, and that it has actually even sent judges to the African Court, including currently a sitting judge. However, South Africa has not yet made the declaration that would allow non-governmental organizations and individuals in South Africa to access the court directly and take South Africa to the court when they feel that their rights have been violated at the domestic level. And I think this is an opportunity to call on the South African government to show leadership and make that declaration that would allow South Africans and other individuals in the country and NGOs to access the court directly.
Uh, yeah, I mean, it raises a lot of questions because enforcement is another aspect of the power of a court. It may be that they make a ruling, they make a judgment, and if the country doesn't comply or abide by a ruling, then does it have value still? Has that happened?
Yes, there has been an enforcement or an implementation deficit, and this relates to many of the countries against whom judgments have been not been made have not been able to implement or enforce those decisions. The one country that has faithfully abided by all judgments of the African Court is Burkina Faso. It has implemented all the two judgments that the court has issued against it. Other countries, including Kenya, have partially implemented the decisions of the court. Tanzania remains with a lot of judgments against it that it has not implemented. This points to at least two things. One is, again, an entrenchment of impunity and accountability by these specific countries. But two is the abdication of duty by the Executive Council of the African Union. This is the body that is supposed to ensure that whenever judgments are issued against states, they put political pressure to ensure that these states comply with the judgments of the court. So we have a problem where the African Union Executive Council has abdicated its duty. It's not enforcing and ensuring that all judgments of the court are being implemented.
So, at the beginning of this conversation, you talked about protecting the court, but it seems as if the court has very little power and ability to affect the kinds of solutions and responses that citizens demand and require of it. So, what is its value 20 years on?
Yes, the court does not have police powers, and this is true of any other court, the ICC, the International Court of Justice, and even domestic courts. They do not have the powers, the muscle themselves to enforce their own decisions. However, the judgments that in the particular case of the African court that it has made, we have seen positive results across the continent, despite the fact that in individual case by case basis, certain orders have not been implemented. We have seen, for instance, the court affirming freedom of expression in Burkina Faso. We have seen the court affirming environmental rights and health rights in Cote d'Ivoire. We have seen the court affirming and validating the rights of indigenous peoples of the Ogiek in Kenya. Over the last 20 years, the court has established and generated a body of jurisprudence that shows that individuals and peoples across the continent can enjoy those rights and can claim those rights at the regional level. The broader impact of these decisions has been more awareness by publics that these rights can be enjoyed. These rights are not privileges that governments accord, but they are rights that are inherent in individuals and peoples. And therefore, despite the fact that we have had an implementation or enforcement deficit, the court has still been very important. And that's why our report is calling for publicity and awareness raising of the existence of the court, so that more and more individuals can be able to file cases at the court, can be able to access the court. That's why we are calling on all the 34 member states that have ratified the court protocol to also take the next step of making the declaration so that individuals and NGOs can access the court. That's why we are also calling on those states that have not yet made the ratification, including that have not made the ratification, to go ahead and make that ratification so that the court has universal ratification and all citizens of Africa and individuals living in Africa can be able to access the court.
We're running out of time, so very briefly, what one concrete step would you most want to see the African Union governments take this year with regards to this court?
The one most concrete step is for those that have not ratified the court to do so, but also African Union to increase the budget of the African court when it meets for its media coordination meeting later this month.
My dear brother, thank you so much indeed for joining us on Channel Africa's Rise and Shine.
Thank you so much. It was a pleasure.
That was Japhet Biegon, who's Deputy Regional Director for East and Southern Africa at Amnesty International, taking a look at 20 years of the African Court. And yeah, big questions being raised. Why only 34